Good morning, or good afternoon, depending on where you are listening in from today. On behalf of the McGuireWoods Education Law Team, it is my pleasure to welcome you to today's webinar on the final Title IX regulations released earlier this month and effective August 14. It is our goal today to make this presentation as practical as possible and to help you focus on the areas where you may need to change your current policies and practices. My name is Craig Wood. I practice education law out of our Charlottesville, Virginia office, representing higher education institutions and K-12 schools. I'm joined today in Charlottesville by Micah Schwartz, in Richmond, Virginia by Heidi Sigmund, and in Charlotte, North Carolina by Abby Golden, all of whom also practice education and employment law and are members of our education law team. Just as technology allows our presenters to be scattered and to practice social distancing, we welcome almost 200 of you from the East Coast to California, and we're glad you could attend the webinar today. So here's what we are going to cover this morning. First of all, changes to the overall program requirements and the handling of complaints up to the filing of a formal grievance. As we'll discuss, the formal grievance step becomes very important in the new regulations. And then we'll talk about changes that come at and after the formal grievance step. So once you have a formal grievance, your hearing and informal resolution options have changed under the new regulations. Interestingly, there are only 26 pages of regulations, but they're embedded in over 2,000 pages of preamble that explains the rationale for the changes. So hopefully what we can help you understand is the regulations are not really that complicated, but there is a lot of context to understand the why and the goal for the different pieces of the regulations. The stated goal of the new regulations is to limit the areas over which schools have accountability, to ensure due process protections for respondents, the people charged with sexual misconduct, to eliminate implicit bias through enhanced training, and to provide support and informal processes that will enable schools to resolve all but the most serious cases. So we're going to cover each of those topics today. What we want to accomplish as we cover those topics are these things. August 14 is the effective date of these regulations, so the changes need to be in place by August 14. Now, everybody has a different process for approval of policy changes. Many policies are set by boards, whether they're higher ed boards or K-12 boards, and you may need board approval to actually change a policy, which means you have to have a board meeting and go through your bylaws or other regulatory process. So you need to factor that into your timing. We don't intend to go over every change. We're going to focus on the major changes and the legal questions that we know will confront you. We're not taking any political positions. This is politically neutral. We're going to focus on compliance. And then we do have an opportunity for you to ask questions as we go along. At the bottom of your screen, you'll see a Q&A button. If you push the Q&A button, it allows you to type in a question, and then when you send us the question, we will either answer it to you individually, or if we think that it is useful to all of the folks on the line, then we'll try to answer it at the end of the presentation. So feel free to send your questions, and if it's a complicated question, we may get back in touch with you after the webinar and talk about it at that time. So these regulations are different from the Obama-era guidance that you've been operating under through the Dear Colleague letters that were issued in 2011 and 2014. How is it different? Well, first of all, this went through a formal rulemaking process. It can't simply be rescinded by the next administration. Doesn't matter who wins the next election. This is going to be the law for a long time, regardless of who is in office on January 1. So the time you invest now in getting your processes, your procedures, your policies in order will pay dividends for you for a considerable period of time. From a big picture perspective, a lot of commentators have argued that these regulations are a departure from prior legal protections for victims. Other commentators, and I think the more recent commentators, recognize that in many ways these regulations simply incorporate the legal principles that were set out in two prior Supreme Court cases, Gebser versus Lago Vista in 1998 and Davis versus Monroe County Schools in 1999, both of which incidentally were authored by Justice Sandra Day O'Connor, the first woman on the Supreme Court. The OCR guidance in the Dear Colleague letters actually altered the Supreme Court standards on liability. These regulations return us to the framework set out by the Supreme Court. So the standard for liability that was set out in those Supreme Court cases in the late 90s and the standard that is reflected in these new regulations is what is called deliberate indifference. It is a failure to act. If the school, the college, university, or K-12 school takes actions that are not clearly unreasonable in light of the known circumstances, then they will have met the liability standard. Now, obviously, we want to operate as a matter of best practice well above the liability standard. We should never get close to that. That is a very high bar. It is unlikely that a school would be held liable under that bar if it took any reasonable action. So what we're after here is a pursuit of best practice, not just trying to meet the bare bone regulation. The likelihood of liability is certainly reduced, but equity is still very much an issue, and if the equitable procedures for respondents are not met as set out in these regulations, we're going to continue to see a great deal of litigation by respondents. You're probably aware that there have been anywhere from 150 to 200 and plus lawsuits by respondents at the college and university level who have been disciplined for sexual misconduct and felt like they did not get a fair process. And trying to restore a sense of equity and fairness is going to be very important. We need to have well-documented policies that people have access to, that they know where to find things. We need to have clear reporting routes. The role of the Title IX coordinator is particularly important in these regulations, and we'll be talking about that. Being responsive to complaints continues to be very important, but there are some options on how to do that. It's important not to have an agenda as you go through these Title IX processes. Implicit bias is still going to result in litigation, and the way to avoid implicit bias as set out in the regulations and as common sense would tell you is to do effective training of anybody involved in the Title IX process. You're going to need to train your investigators. You're going to need to train your Title IX coordinator. You're going to need to train your decision makers, your panel members who are deciding these cases. Because if you don't have training on the expectations of these regulations, you're likely to default back to the same implicit bias perceptions, at least, even if it's not actual, but we know that perception's important. It will default us back to the perceptions that have led to so much litigation against higher education institutions. So setting that out as a framework, I'm going to turn the microphone over to Heidi Sigmund, who's going to talk to you about the jurisdictional issues that are different in these new regulations. Heidi?
Sure. Thank you, Craig, and thank you all for joining us. As Craig mentioned, I am with McGuireWoods in Richmond. I'm a member of the Labor and Employment team, and I focus on higher education. And I'm going to talk about sort of the scope of the new Title IX regulations. What is a Title IX problem and what's not? What are some of the new concepts introduced by these regulations? And I'm going to do that by walking through several of the key definitions that are implemented in these regulations. So, without further ado, the first major definition I want to talk about is the definition of an education program or activity. Obviously, Title IX itself only prohibits discrimination in an education program or activity, and the proposed regulations that the Trump administration issued in 2018 sort of just parroted that language saying education program or activity. And there were a lot of comments and concerns about whether and to what extent Title IX is intended to cover off-campus conduct. So the final regulations add two provisions that are specifically targeted towards off-campus conduct. The first is that an education program or activity includes any locations, events, or circumstances where the school exercised substantial control over both the respondent and the context in which the sexual harassment occurs. So again, the major issues are going to be, number one, did the school have control over the circumstances? And number two, did the school have control over the respondent? I don't want to get too much into legal etymology here, but as Craig mentioned, a lot of these definitions come directly from the Supreme Court's decisions in Gebser and Davis. And in this case, the department just lifted this definition directly from Davis. In some cases, I think picking language up from Supreme Court decisions is helpful, and we are aligning the regulations with what the Supreme Court has been doing. But in this situation, I think it potentially creates more questions than it answers. And that's because when the Supreme Court was discussing a school having substantial control over the respondent and over the circumstances, it was talking about fifth graders who were on elementary school property. Obviously, elementary schools, K-12 schools, have much more plenary control over their students than do colleges and universities. And so that was why the Supreme Court used that phrasing. And so now we're sort of putting it in a vacuum, and we have to figure out what it means in the college and university context. I think the main place you'll see this come into play is that Title IX will need to cover off-campus school-sponsored events. That gives the school substantial control over the circumstances. And as far as having substantial control over the respondent, I think that would certainly cover employees who are representing the school at off-campus activities. It could also potentially include contractors or volunteers, or maybe even students, depending on the degree of control over the circumstances. On the other end of the spectrum, I think it's unlikely that any court or the department would try to say that a school has substantial control over two college students who are at a private off-campus apartment. The point here, and what the Department of Education was getting at, is that the school should not be liable for harassment over which it does not have control. The second new part of this education program or activity definition is that Title IX includes any building owned or controlled by a student organization that is officially recognized by a post-secondary institution. So the Department of Education was very clear that they wanted to cover off-campus Greek life. And this provision will cover off-campus fraternity and sorority houses, even if the school doesn't own the house, and even if none of the members of the fraternity or their families own the house. The question is whether the organization itself owns or controls the house. That brings the building within Title IX coverage. We think this would also potentially cover events that are off-campus that are put on by campus organizations. So, for example, if the fraternity rents a hotel in town to put on a formal, that would be covered under this part of this definition. On the flip side, we do not think this covers, for example, 5 students on the club soccer team who just happen to live together in a house. We were discussing this yesterday, and we think this provision is kind of poorly written in this regard because it's really not clear from the language itself, but because this was so clearly targeting official organizational control, we do not think this should be read to cover off-campus organizations whose members just happen to live together in a particular house. You're going to be looking for some sort of indication of official control here. One other thing that the Department of Education clarified in these final rules is that they do not cover study abroad programs. So as a legal matter, I think this is certainly the right answer because Title IX specifically refers to any person in the United States, and the Obama-era OCR had to kind of ignore that to try to pull in sexual misconduct that occurred in study abroad programs. That said, with regard to study abroad, with regard to the off-campus soccer house that I was just discussing, nothing in the regulations prevents schools from voluntarily applying their Title IX procedures to this type of misconduct. But that's something that each institution will have to decide, is whether and to what extent they want to cover those types of off-campus misconduct or study abroad misconduct that isn't strictly a Title IX issue, whether they want to include all the Title IX bells and whistles for those types of issues, or whether they want to route those types of issues into a sexual misconduct process that does not include all of the Title IX trappings. The next definition I want to talk about is the definition of sexual harassment. So there are a number of changes here to the definition. The bottom line here is that the department was trying to emphasize, they're trying to raise the threshold here. They're trying to raise the threshold for what constitutes sexual harassment. And again, they're trying to match this up with what the courts have been doing for the last 20 years. So there are 3 categories as far as what counts as sexual harassment under these regulations. The first category is called quid pro quo, which is defined as conditioning educational access on unwelcome sexual misconduct. Basically, if the student will have sex with me, I'll give her a better grade kind of thing. And the important thing to note about this is that it only applies to conduct by school employees. It does not cover conduct by, for example, a volunteer or another student. The second category under sexual harassment is defined as unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to an education program or activity. This is perhaps the most significant change from the prior OCR guidance, which said, if you have harassment that's either severe or pervasive that would in any way limit a student's access to education, that could constitute sexual harassment. Again, here is where the department is trying to say this needs to be objective harassment. It can't just be someone who is particularly sensitive. The third part of this definition incorporates 4 components from the Violence Against Women Act, and those are sexual assault, domestic violence, dating violence, and stalking. I think for most people, common sense would tell you that those should be included in the definition of sexual misconduct in your Title IX policy, but the department just wanted to be clear that a single incident that falls into any of these categories can constitute sexual harassment. So the major shift in thinking that I think this definition highlights, and also some of the other definitions as well, is that Title IX does cover employee-to-employee sexual misconduct. I think traditionally schools tend to think about student sexual misconduct as a Title IX issue and employee-to-employee sexual misconduct as a Title VII issue. And these new regulations essentially require schools to disregard that distinction. I think employee sexual harassment reports that typically may have been exclusively an HR issue are now also a Title IX issue. And so in addition to revising your Title IX policies, this will require changes to your employee handbooks, to collective bargaining agreements, and also potentially to employment agreements to make sure that these employee sexual misconduct issues are being routed appropriately. The next definition that's going to be really important is the definition of actual knowledge. So under the new regulations, actual knowledge is notice of sexual harassment or allegations of sexual harassment. And here is a place where the regulations diverge pretty starkly between K-12 schools and colleges and universities. In the K-12 context, any employee of an elementary or secondary school can be a mandated reporter. Any employee other than the respondent himself or herself, any employee who has knowledge of these allegations means that the school district has knowledge. In the college and university context, schools now have more flexibility about who is considered a mandatory reporter and who is not. The regulations make clear that just because someone receives training about sexual harassment, that does not make the employee someone who has authority to institute corrective measures under this regulation and someone who necessarily imputes actual knowledge to the school. So this is another area where you're going to want to make sure that your policies clearly lay out who is a mandatory reporter and who is not. One of the main concerns here was that the department wanted students to be able to confide in faculty members or employees without fear of triggering the formal Title IX process. So it's going to be important to make sure everyone knows who those people are and they know what their obligations are. The next major sort of definitional change that I want to talk about is this sort of bifurcated response process. And I'll explain a little more what that means. So one of the concerns that a lot of commenters raised about the proposed regulations was that they made it difficult for victims to get help because they had to file a formal complaint to trigger the school's duty to respond. So now the final regulations tend to bifurcate between a report of sexual harassment and a formal complaint. Obviously, a report can ultimately turn into a formal complaint, but a report can trigger the school's duty to respond. And a report can come from anyone. It can come from a bystander. It can come from a parent. It does not necessarily have to come from the complainant or the victim himself or herself. And it can come in by phone or by mail, any way that it gets to the Title IX coordinator. The school must respond. And so upon receiving any report of sexual harassment, again, that's sort of an informal allegation of sexual harassment, the Title IX coordinator must promptly contact the complainant. And that is defined as the person who is alleged to be the victim. So if an informal report comes from a third party, the regulations direct the Title IX coordinator to promptly contact the alleged victim, assuming that person can be identified. And when the Title IX coordinator contacts the complainant, the regulations require the coordinator to discuss the availability of supportive measures, which we'll talk about in a minute, to consider the complainant's wishes with regard to supportive measures, explain that those measures can be available with or without filing a formal complaint, and to explain to the complainant the process of filing a formal complaint. And It's very important in this conversation to document the Title IX coordinator's outreach to the complainant. The regulation's record-keeping provision actually requires schools to document why they did not provide a complainant with supportive measures if they choose not to do so, and the Title IX coordinator has to explain in this documentation why it is not deliberately indifferent. Basically, why is the school not liable for not giving this person supportive measures? So it's very, very important to make sure that this conversation is carefully documented. One other change from the proposed regulations to the final regulations is that the new regulations omit the proposed requirement that a Title IX coordinator file a complaint whenever the coordinator has received multiple complaints about the same respondent. So there was concern that that was taking autonomy away from the victims as far as what sort of process they wanted to pursue. So that is not in the formal regulations. And obviously Micah and Abby are going to talk more about what happens once you receive a formal complaint as defined on this slide. Two other things that I want to touch on. The first is the concept of supportive measures. I mentioned these a moment ago. These are sort of a new concept. They had been somewhat introduced in the Obama-era guidance, which used language like interim measures, but the Trump-era guidance really builds on this and really essentially requires schools to provide supportive measures in pretty much every case. What does that look like? Supportive measures are defined as non-punitive, so not disciplinary, individualized services offered as appropriate and to no charge to a complainant or a respondent, even if there's no formal complaint, before filing a formal complaint, or after filing a formal complaint. And as far as the details of what those measures look like, the regulations give institutions a fair amount of flexibility. But examples include counseling, extensions of deadlines or other course adjustments, modifications of work or class schedules, campus escort services, restrictions on contact between the parties, changes in housing locations, leaves of absence, or other types of increased security. So the point is that the department wants these measures to be available to both complainants and respondents throughout the entirety of this process. The last concept that I'm going to talk about is the idea of informal resolution. This is a major change from Obama-era guidance, and we think it's one of the more positive aspects of the proposed regulations. You've been seeing a lot of attention probably about the adversarial nature of the grievance process that Abby and Micah will talk about in a minute, but the informal resolution aspect of this gives schools and complainants and respondents the opportunity to avoid some of those adversarial processes. So the idea there is that once a complainant has decided to pursue a formal complaint, the school can offer informal resolution. And one important exception there is that informal resolution is not available for complaints that allege misconduct by an employee against a student, because there are concerns there about the power differential. But in any other sort of formal complaint, the school can offer informal resolution. The two primary forms I think we'll see that take are mediation and restorative justice, which both involve engaging a neutral party to facilitate a resolution. So schools will want to decide as a policy matter what kind of informal resolution they want to make available. But regardless, the facilitators of those resolution processes will need to receive training. They'll need to receive the same sort of anti-conflict of interest and anti-bias and sexual harassment training that your Title IX investigators and coordinators receive. And the last piece of this that I want to touch on is that, there are relatively few changes from the proposed regulations when it comes to informal resolution, but one of the changes is emphasizing that this really needs to be voluntary. So before initiating informal resolution, the Title IX coordinator should provide both parties in writing notice of the allegation, the requirements of the informal resolution process. What is it actually going to look like? If you engage in this process, at what point can you no longer return to the formal complaint process, and what will be kept confidential and what will not be confidential? And as far as making sure that that's voluntary, the school cannot impose any conditions on engaging in informal resolution. You can't say, you can't take this class if you insist on pursuing a grievance process instead of engaging in formal resolution, because the schools did not want to pressure parties one way or the other about pursuing formal grievance processes. And so with that, I'm going to turn it over to Abby to talk about that grievance process.
Thanks, Heidi. As Craig mentioned, my name is Abby Golden, and I'm in McGuireWoods Charlotte office. I do general commercial litigation, and I also practice education law with our education team. My portion of the presentation covers how a school must respond to formal complaints when the complainant does not opt for an informal resolution process. So, in short summary, after receiving a formal complaint, an institution must follow a grievance process that complies with the set of regulations that is set out in Section 10645. I will be summarizing the main principles that an institution must abide by as when it establishes an equitable grievance process, as well as the minimum requirements for a formal Title IX investigation and also staff training. I will also then cover the grounds for both mandatory and discretionary dismissal of formal complaints prior to a determination of responsibility through a live hearing. So, to start, it is important to understand the general principles which must guide institutions as they craft a grievance process that complies with the new rules. In particular, Section 10645 codifies general requirements aimed at ensuring that the grievance procedures treat complainants and respondents equitably. It further states that sanctions cannot be imposed on a respondent absent a determination of responsibility through a formal grievance process that complies with Section 10645. So a compliant grievance procedure must be a predictable process that presumes the respondent is not responsible for the alleged conduct. So importantly, this means that the respondent does not have to prove innocence. And as Craig discussed earlier, and as some of you may know, the lack of this presumption created the implicit bias problem, and it led to hundreds of lawsuits by male respondents against colleges and universities based on allegations of unfair treatment. So to that end, the new rule also acknowledges that an institution's treatment of a complainant or a respondent can constitute sex discrimination that is prohibited under Title IX. So to avoid teacher liability, it is critically important to craft a grievance process that complies with Section 10645. One important element in the new rule that is aimed at ensuring equality for the formal grievance process is the disclosure requirement. So specifically, the rules impose disclosure requirements so that both parties understand critical information about the institution's procedures for investigations and hearings. So at the outset of the process, the institution must provide both parties with a description of the process, the applicable standard of evidence, a summary of possible sanctions based on the allegations in the formal complaint, a description of appeal rights, and also a list of available supportive measures for both parties. So one important note before we move on to discussing the investigations is that the proposed rule offered a safe harbor against a finding of deliberate indifference or some other finding that a school committed sex discrimination if schools followed procedures that were consistent with Section 10645 in response to a formal complaint. That safe harbor has been removed, so it is no longer in the rule. So moving now to the investigation portion of the formal process. Before the investigation begins, the institution must notify, again, both parties of the allegations that are in the formal complaint, and also notify them of their right to select an advisor to stand with them through the process. Second, while the new rules are focused on an equitable grievance process, there is nothing in the new rules that prohibits an institution from immediately removing a respondent from the education program if the institution determines that the respondent poses an immediate threat to health and safety. Emergency removal is discussed under a different section of the regulations, Section 10644, and it's important to note that it is not a substitute for reaching a determination of the respondent's responsibility for the sexual harassment allegations. So rather, emergency removal is for the purpose of addressing imminent threats posed to any person's physical health or safety, which might arise out of the sexual harassment allegations. Therefore, removal at this stage does not obviate the institution's duty to continue with the grievance process after removal. So, after notifying both parties of the allegations, the new rule imposes a burden on the institution to gather evidence sufficient to reach a determination regarding responsibility. The process of gathering evidence is generally left up to the institution by the rules, but there are some guidelines. Notably, the rules provide that institutions may not prohibit the parties from discussing the allegations during the investigation with anyone. That means there can be no gag orders on any respondent or complainant during the course of the investigation. In addition, all evidence directly related to the allegations, is how it's defined, must be provided to both parties. Also, despite the fact that the institution bears the burden to gather evidence, the institution must also provide both parties with an equal opportunity to present witnesses, including fact and expert witnesses, and also offer other inculpatory or exculpatory evidence. And finally, there are two types of evidence that are off limits during the investigation procedure. First, evidence that is subject to a legal privilege, and second, medical and psychiatric records. The prohibition on accessing medical and psychiatric records is a new provision that was not included in the proposed rule. It states that a school cannot access, consider, disclose, or otherwise use a party's records that are made or maintained by a physician, psychiatrist, or psychologist, so long as those records were made and maintained in connection with treatment of the party. That said, if the party consents in writing for the school to access the records may be used. And the same goes for legally privileged information. If the holder of the privilege consents to the use during the investigation, it may also be used. So the culmination of the investigation is a written investigative report that must fairly summarize all relevant evidence. And I put emphasis on the word all because the department defines the word relevance very broadly. And that means that this report could end up being a voluminous document, and preparation could involve a significant amount of work on the part of the investigator. It will just depend on the nature of the allegations and the evidence collected for each complaint. In addition, the report must be prepared in advance of the hearing and sent to both parties at the same time. The rules provide specifically that it must be sent to them at least 10 days in advance of the live hearing. The parties must also have an equal opportunity to respond in writing to the report. So this concludes my summary of the investigation phase of the formal grievance process, and I'm going to switch now to discussing the training that staff members involved in the Title IX process must receive before they can participate. And before I do that, I want to touch on something that I'm sure many of you are already aware of, which is that the final rules, like the proposed rules, reject the single investigator model that was previously permitted to be used by schools. So the final rules state that schools and universities must provide for live hearings for formal complaints of sexual harassment, and that is going to be a burdensome change for many schools. It also states that the decision maker, which is the individual who presides over the hearing, cannot be the school's Title IX coordinator, nor can it be the person who conducted the investigation and prepared the final investigation report. So keeping that in mind, I'm going to turn now to the training requirements that are codified in the new rules. The new rules put a heavy emphasis on making sure that the parties involved in the formal grievance process, meaning the investigators and the decision makers, are specifically trained to be free from bias and conflict of interest. They also must have sufficient training to carry out their specific roles. So both investigators and decision makers must receive training on how to determine relevance of evidence, including how to apply rape shield protections provided only for complainants. In addition, investigators must be trained on how to create an investigative report that fairly summarizes the relevant evidence, and decision makers must be trained on how to use any technology that will be in use during the live hearing. So while those two parties have particular training requirements for their roles, the rules also contain broader training requirements for all parties involved in Title IX work. That means the investigator, the decision maker, the Title IX coordinator, and also any person who facilitates an informal resolution process. So that would be a mediator or some other party that would be involved in any kind of restorative justice action that was taken. So specifically, an institution must ensure that all of these parties are trained on jurisdictional issues like the definition of sexual harassment and the scope of the institution's educational program or activity. They also must be trained on how to conduct the investigation and grievance process in line with the requirements of the rules, and also how to serve impartially and without bias, and how to avoid and be free from conflicts of interest. So this is really a foundational issue that goes back to the principles of equity that are codified in the new rules that I discussed and that Craig also touched on in his presentation. A rigorous training process will be an important element of compliance with the new rules. And in addition, the new rules provide that training materials either must be posted online on a website or otherwise be made readily accessible to the public. So there will be an accountability element with the training materials too. A lot of the issues that you're going to have to consider as you begin to create a formal grievance process are kind of summarized at the bottom of this slide. So it's questions like, how will you ensure that your decision makers and investigators are free from bias and do not have a conflict? How will you ensure they know how to make good judgments about when to dismiss a case for lack of jurisdiction? Do decision makers understand what relevance means as applied to evidence? And also, who will do your training? So now we will turn to the issue of when an institution must or may dismiss a formal complaint prior to a determination of responsibility. There's only one basis for mandatory dismissal, and that's lack of jurisdiction. So schools must dismiss allegations of conduct that do not meet the final rule's definition of sexual harassment or did not occur in a school's education program or activity within the U.S. In addition, such dismissal, as Heidi touched on earlier, is only for Title IX purposes and does not preclude the school from addressing the conduct in any manner that the school deems appropriate under its conduct code. So while there's only one basis for mandatory dismissal, there are several scenarios in which an institution may exercise its discretion to dismiss a formal complaint. First, institutions may dismiss a formal complaint or allegations therein if the complainant informs the Title IX coordinator in writing that the complainant desires to withdraw the formal complaint or allegations therein. Second, a school may dismiss a formal complaint if the respondent is no longer enrolled or employed by the school. And then finally, a school may dismiss a complaint if specific circumstances prevent the school from gathering sufficient evidence to reach a determination of responsibility. Finally, when a school dismisses a formal complaint, whether due to the mandatory provisions or discretionary, both parties must be simultaneously notified. And as I mentioned, dismissal does not preclude the school from punishing the respondent under a different aspect of the school's conduct code. And now that I have discussed the grounds for dismissal, I'm going to turn it over to my colleague Micah Schwartz to discuss the formal hearing.
Thank you, Abby, and good morning, everyone. This is Micah Schwartz. I am an attorney in our firm, Charlottesville, Virginia office, and like the other presenters, I also focus on education law. This is going to be the last section of the presentation. I'm going to be focusing on the formal hearing process, and in addition to that, the responsibility determinations coming out of the hearings, and then also appeals of those decisions. I'll likely go towards the end, or to the end of our time. We're gonna try to end at exactly an hour. If there's extra time, we'll address some of the questions at the end as well. So as Heidi said, this is the part of the regulations that has probably received the most attention, and this was likewise the case when the proposed regulations were issued about a year and a half ago, because they're the most dramatic, or at least they may require the most dramatic changes for some institutions. When informal measures are not going to do the job, and respondents require the opportunity for a hearing, institutions are now going to have to provide formal trial-like procedures to resolve these kinds of allegations. That's why I have a picture of Matlock here, because for the first time, at least for a lot of our clients and for a lot of educational institutions, it's going to be necessary to provide a trial-like setting to deal with these allegations. They will be formal and adversarial and more legal than a lot of institutions are used to dealing with. Matlock will probably be lost on most of your students, but hopefully the reference means something to the rest of you. So let me explain what I mean by an adversarial trial-like setting, just by giving you kind of the basics of what the regulations require, and then I'll drill down a little bit on each of these bullets. So first of all, colleges and universities will have to provide live hearings for these formal grievance procedures. And this is another one of the areas where there is a divergence in terms of how colleges and universities on the one hand and K through 12 institutions on the other will have to respond. The regulations require that colleges and universities provide live hearings, whereas for K through 12 institutions, the regulations only say that they may. And so in most cases, most K through 12 institutions can probably choose to continue doing more informal procedures, except for sexual assault cases, which thankfully are more rare in that setting. So a lot of the procedural requirements that I'm going to talk about over the next couple of minutes don't apply as much for K through 12 institutions, and instead will only apply if they do choose to provide live hearing opportunities for complainants and respondents. Other formal hearing requirements: institutions will have to provide parties with advisors of their choice who don't have to be lawyers, but the regulations allow for them to be. And as we talked about it last time, we discussed these regulations again about a year and a half ago. It begs the question, if one party is coming to the hearing with a lawyer, does that mean the other side needs to lawyer up too? And if so, then you really do have, again, a trial that's about to happen on campuses. And then third, advisors must be allowed to conduct cross-examination of parties and witnesses, and the cross-examination has to be live. Let me explain a little bit more about what live means, because it's a term that comes up often in these regulations. So the regulations say that the hearings themselves must be live, which means that parties' advisors must have an opportunity to pose questions directly to the witnesses. So it won't be sufficient for parties' advisors to just be able to provide questions on paper to the witnesses. That's not going to do. And it won't be sufficient to provide the questions to the decision maker to pose to the witnesses. Some institutions do that. That's not going to be good enough anymore either, because that's not, as far as the regulations are concerned, a live hearing. But, and I think this, maybe the language here is somewhat contradictory, but the concepts aren't. While the hearing has to be live, it can be virtual, meaning it will be okay for the parties and the witnesses to be in different rooms and to be watching and listening and participating virtually. So this could prove really important over the course of the next year, because you can certainly imagine a circumstance in which students are back on campus in the fall, an alleged sexual assault occurs and is filed, and then there's an uptick in COVID cases and the students go home, universities are still going to be required to provide prompt resolutions of the allegations, and so they may have to conduct these hearings virtually, say through Zoom. The regulations seem to make that okay, provide for that, even though that the hearings have to be live. So as I said, to have a live hearing, parties must be able to provide cross-examination. To be more specific, advisors of the parties must be allowed to provide cross-examination, but the parties themselves may not. So thankfully, we don't have to have a circumstance in which a respondent is grilling a complainant about the night in question. Instead, it is only the advisors who are allowed to conduct the cross-examination. The cross-examination has to be direct, oral, and in real time. Now, Title IX applies to the recipient institutions. It doesn't apply directly to the student. So the institutions have an obligation to provide for cross-examination, but a particular party or witness can still choose not to be cross-examined. A complainant can say that I refuse to be cross-examined. But there are implications of that. So first of all, if a respondent chooses not to be cross-examined, the rules say that that decision makers can consider that decision in making a responsibility determination, but the decision makers cannot make a responsibility determination based solely on the fact that the respondent said that he or she didn't want to be cross-examined. Second, a decision maker may not rely on a statement that wasn't cross-examined. That's a needle to thread, I think, for decision makers. Again, they can't rely solely on decisions not to be cross-examined, but at the same time, they cannot rely on statements that weren't cross-examined. You can certainly imagine some decision makers getting that wrong. Again, I think a judge might get that wrong, and a professor or a dean of students, staff member who's being trained to be a judge could certainly get that one wrong. An exception is that if a party makes a statement against interest or an admission, then we think it's probably unnecessary for those to be cross-examined, and then therefore it would be okay for a decision maker to rely on that statement. We got a message that the audio is cutting out some. Hopefully all of you can hear me. I'll try to speak as clearly as possible. As part of these cross-examinations, decision makers are going to have to make relevancy determinations about whether the cross-examination questions address relevant issues. The regulations make it seem like every question is susceptible to a relevancy challenge, and that the decision maker is going to have to provide an explanation about whether or not the question addresses a relevant issue on the spot with an explanation. That makes sense, but again, it's worth noting that that's something that even a judge in a federal court isn't required to do. A judge in a federal court can make a relevancy determination without providing an explanation. And it may make sense to do so in a typical court setting because that allows the proceeding to continue and allows the cadence of the cross-examination to continue. If an advisor is objecting to every question on relevancy grounds and the decision maker has to provide a relevancy decision with an explanation, that's going to really cut up the cross-examination, I think, and make it potentially less effective. There are some limitations to the cross-examinations. Rape shield principles still apply here, so advisors cannot ask about a party's sexual predisposition or prior sexual behavior, except in some limited circumstances. And then finally, treatment records are not relevant. What I mean there, this goes back to what Abby said a minute ago. The rules are designed now to make it less common, let's say, for doctor or psychologist treatment records to be a part of the investigation reports, and therefore they're less likely to be a part of the hearings as well. So now, after all the evidence has been provided, the decision makers will have to make a responsibility determination. They can make the decision based on either a preponderance of the evidence standard or a clear and convincing standard. The second, the latter one, is the higher standard. The rules allow for either, except that they say that whatever standard is applied to students must also be applied to employees. And for those of you who have unionized workforces, this could be an issue if the standard is actually a part of your CBAs, then you're going to be required either to renegotiate the CBAs or make the standard that applies to students consistent with what's in the CBA, at least until the next CBA is negotiated. The determinations, again, following with our themes here of formal and legal, they have to be in writing, and they're going to have to look a lot like legal opinions. They have to provide the facts. They have to explain what the sexual misconduct policy is that applies. They have to apply the policy to the facts. And if there's a responsibility determination made, then the decision makers are going to have to recommend a sanction. Last topic I'm going to talk about is appeals, and then we'll end for the day. They must be made available in at least 3 circumstances. If there's a procedural irregularity, if there's new evidence that is found after the decision is made, or if there's a conflict of interest or bias. These must be provided if it's concluded that they would have affected the outcome. I think that's going to be hard to say in a lot of circumstances. It's hard to know whether one of these things actually affected the outcome. So institutions may find it easier to just provide appeals freely. And they may provide appeals in other circumstances as long as they provide them equally both to respondents and complainants. And finally, again, these appeal decisions have to be formal, kind of like the hearing decisions. First of all, they must be heard by new decision makers. It can't have the same people serving on panels both at the trial level and at the appeal level. The parties must have the opportunity to submit a brief. And after the appeal panel has heard arguments, they must provide written decisions. And that's why I have a picture of the Supreme Court here. These are going to have to read like legal opinions from an appellate body. So that's the end of our presentation today. It's almost exactly 1 o'clock, so I don't think we'll have time to take any questions. Some people wrote some to us, which we appreciate, and we'll get back in touch with you. Thank you for joining us all today. And if you have any questions or if we can help you with this process at all, we'd love to. Please reach out to us. You should see our contact information, the invitation that you received to join this webinar. And if not, of course, you can find our contact information on our website, which is McGuireWoods.com. Again, on behalf of the rest of the presenters, thank you for joining us today, and have a nice day.